A North Carolina doctor is challenging the state's certificate of need law, and the case heads to a hearing in court this week. Joining us for an update on this case, what it means, why it's important, is John Guze. He is senior fellow in legal studies at the John Locke Foundation. And John, why is the state's certificate of need law something that we should be paying attention to?
Well, there's a couple of reasons, Mitch. One is it's just unconstitutional. The Constitution forbids monopolies. It forbids exclusive emoluments. It forbids taking anybody's freedom without due process of law, which, as it's interpreted by the courts, means without a very good reason. But it's also bad for everybody in North Carolina. It raises the cost of medical care. It makes it less convenient. And so we think it's wrong, and it's also just a bad idea. It hurts North Carolinians.
Now, a doctor, Dr. Singleton, has decided to take this law to court.
He wants to perform outpatient oral surgery at his facility.
Tell us about why this doctor has decided he wants to go ahead and challenge the law.
Well, Dr. Singleton has been performing outpatient eye surgeries for 30 years. He's done hundreds of them, and he's allowed to do them under North Carolina law. He's got a certified operating theater at his practice. He meets all the standards for operating it safely. And under the CON law, the certificate of need law, he's allowed to do outpatient eye surgeries on a limited basis, and he does. And when he does, they cost much less than they do at the hospital, and they're much more convenient for his patients. But because of the certificate of need law, he can only do a few of them a month instead of doing all the ones that his patients would like. So most of his patients, he has to refer them to the hospital, do the surgery there at much greater cost and much more inconvenience. That's absurd from his patient's point of view, and it's absurd as far as he's concerned. And he's also a man of principle, and he thinks this is just wrong, so he's challenging the law.
Now, he has gone to court. The John Locke Foundation is not a party to the suit, but is getting involved through what's sometimes called an amicus, or a friend of the court brief. Tell us how the John Locke Foundation is contributing.
Well, we asked the court for permission to intervene in the case, because this is something we're very interested in. And Judge Afluta said yes, he granted our motion. So we submitted a friend of the court brief explaining why, in our opinion, Dr. Singleton is right, and the state of North Carolina, the Department of Health and Human Services, is wrong to defend this law.
This case heads to a hearing this week. Tell us what is supposed to happen this week.
The state has asked for this case to be dismissed. They say that Dr. Singleton hasn't even stated a claim for which relief can be granted. And part of the reason they say that is because he hasn't exhausted all his administrative options in terms of obtaining a certificate of need and being allowed to practice the way he wants to. In our brief, we argue that that's absurd, because all those hurdles that stand in the way of him possibly getting a certificate of need are a barrier in and of themselves, an unconstitutional barrier. It would probably cost something like $300,000 or $400,000 and years of time for him to pursue an application for a certificate of need to its conclusion. And the probability is that even if he did, he wouldn't get one. So that in and of itself is an unconstitutional barrier to practicing his profession, as the state has already agreed he's well able to do safely for the people of North Carolina.
If this hearing turns out the way that folks who have concerns about CON turn out the way that you hope it will, what will happen? Basically, the court will say, no, state, we're not going to dismiss this case?
Right. At this hearing, or after the judge deliberates after the hearing, he probably won't make a ruling on the spot, but we hope that he'll deny the motion to dismiss and allow the case to go forward, so that Dr. Singleton and all the other interested parties, because there are quite a few amici, that all of us can present our evidence, and that once he hears that, he'll say, you know what, this law as it applies to Dr. Singleton is unconstitutional, and he's got to be allowed to go ahead and perform these surgeries at his facility without a certificate of need.
Ultimately, Dr. Singleton would like to be able to perform all of the surgeries that he wants to perform and not have to have this requirement. From the John Locke Foundation's vantage point, what do we hope happens here? Basically, a court determination that CON is unconstitutional, at least in this case?
Right. That's the best we can hope for. And it would be a lot. It wouldn't strike down the law completely. It wouldn't say that nobody else ever has to apply for a certificate of need, but it would set a very important precedent. It means that anybody else similarly situated to Dr. Singleton could go ahead and practice medicine without obtaining permission from the state to do it. It would also, I think, indicate that the writing is on the wall for this law, and it would put a lot of pressure on the state legislature to finally repeal it. These certificate of need laws, there's never been a justification for them, and there certainly isn't now. We have an appendix to our brief that lists dozens of research papers that show that certificate of need laws do not protect public safety. They do raise prices. They do harm patients. They do harm taxpayers. They do harm insurance companies. So we want to get that evidence in front of the judge, and we think if he looks at it, he'll come around and see that this law is certainly unconstitutional as it applies in this case.
As the case moves forward, we know that one person who's going to be watching very closely, not the least reason of being that he has a dog in the fight, having filed a brief in the case. John Guze is Senior Fellow in Legal Studies for the John Locke Foundation. Thanks so much.
Thank you, Mitch.